Good day, I'm Julans and Sanchez, a student of AMA Online Education, under the course of Bachelor of Science in Accountancy. For today's video, I'm going to present all the facts, evidences, factors, and decisions of the court, including my personal acumen regarding the petition, the decisions, and the impact of the decision in future cases. The case entitled Diesel Corp Construction Company Incorporation versus Jollibee Foods Corporation. As stated beforehand, the only issue that will be tackled in the court's resolution is a petition for review under the Rule 45 assailing two resolutions of the Court of Appeals. Facts. Diesel instituted an action for recovery of escalated construction costs amounting to 4.3 million pesos in the Regional Trial Court Makati, which it had allegedly incurred in constructing buildings for respondent Jollibee in Batangas City and in Calamba, Laguna. Jollibee, in its answer, counterclaimed that petitioner allegedly failed to complete the projects on time, so they sought recovery of damages and attorney's fees in the sum of 2.7 million pesos. After trial, the Regional Trial Court ruled the Diesel had completed the both projects on time and was entitled to escalated construction costs. Diesel filed a notice of appeal in motion for execution pending appeal. Jollibee likewise filed a notice of appeal and opposed petitioner's prayer for execution pending appeal. The Regional Trial Court in Special Order allowed execution pending appeal upon the following findings. First, Diesel was entitled to the payment of escalation costs. Second, Jollibee's appeal was only meant to delay the payment. And third, Diesel would post a bond equal to 150% of the total amount of the judgment. Jollibee filed a motion for reconsideration with an alternative prayer that it be permitted to post a supersedeas bond pursuant to Rule 39, Section 3. The Regional Trial Court, however, denied the motion for reconsideration on the ground that the filing of a counter bond was premature because Diesel had yet to file its own bond. Regional Trial Court later forwarded the original records of the case to the Courts of Appeals. Diesel filed with the Court of Appeal a motion for issuance of writ execution on the grounds that the special order of the Regional Trial Court had already become final and executory. Jollibee failed to question its propriety in time, and it was ready to file the required bond. In response, Jollibee filed a comment with motion to stay execution by posting the supersedeas bond. The Court of Appeal, in the first assailed resolution, directed the Regional Trial Court to issue a writ execution upon petitioner's posting of 10 million pesos bond and to stay execution upon respondent's filing of a supersedeas bond of 15 million pesos. Diesel filed a motion for reconsideration regarding the granting of a stay execution, but the Court of Appeals, in its second assailed resolution, denied said motion for reconsideration. Hence, this petition. The issues. The first issue, whether or not a petition for review under Rule 45 is proper remedy to question an order of the Court of Appeals staying execution pending appeal. The second issue, whether or not the Court of Appeal has jurisdiction to issue such order and whether estoppel barred petitioner from questioning the Courts of Appeal jurisdiction. The third issue, whether pendency of an appeal or the posting of supersedeas bond justifies a stay of execution pending appeal. And the fourth is whether respondent is guilty of forum shopping. So let's talk about the first issue. The first issue, a petition for review under Rule 45 is proper remedy question final judgments, not interlocutory orders of the Court of Appeals. A final order disposes of whole subject matter or terminates the particular proceeding or action, leaving nothing to be done but to enforce by execution but what has been determined. Review by this court of a judgment, a final order or a resolution is discretionary. It is not a matter of right but of sound judicial discretion. The court reserves the right to require or allow filings of such pleadings, briefs, memoranda, or documents as it may deem necessary. So this issue was not held. The ratio, Rule 45, is proper remedy to question final judgments, not interlocutory order of the courts of appeals, such as, in this case, a resolution granting to stay of execution. The reason interlocutory orders are those that determine incidental matters which do not touch on the merits of the case or put an end to the proceedings. It is well settled that a petition for certiorari under Rule 65, not Rule 45, is the proper remedy to question an improvident order granting execution pending appeal and thereby relieve the adverse party from the immediate effects thereof. The same principle applies to a stay of execution. Notwithstanding this procedural error by petitioner, the Supreme Court treated the matter as petition for certiorari under Rule 65 to resolve the substantive and important issues being raised. Now, the second issue. The petitioner argues that the Section 3 and Rule 39, the discretionary power to order a stay of execution is compartmentalized in the court that granted execution pending appeal. Petitioner also contends that when it filed its motion for issuance of premature execution, it effectively asked the Court of Appeals to perform a ministerial duty. After the perfection of the appeal and transmit of the records, the trial court loses jurisdiction over the case. Henceforth, it may no longer grant a motion for or issue a writ of immediate execution. To do so would be an abuse of discretion. So this issue was held. The law vests the Court of Appeals with jurisdiction to grant or deny discretionary execution, with or without estoppel on the part of the petitioner. The ratio, the Court of Appeals may not be compelled to enforce a special order issued by the trial court. The Court of Appeals has its own separate and original discretionary jurisdiction to grant or to stay execution pending appeal, except in civil cases decided under rules on summary procedure and in other cases when the law or the rules provided otherwise. From a reading of Rule 42 and 39, Sections 2 and 3, after the perfection of the appeal and the transmittal of the records, the trial loses jurisdiction over the case. Henceforth, it may no longer grant a motion or issue of writ of execution. The reason, while it is true that the trial court granted the motion of the petitioner for execution pending appeal, it did not actually issue a writ of execution because the latter had failed to comply with a special order proviso requiring the posting of a band. Eventually, two separate appeals filed by both parties were perfected, and the records of the case were transmitted by the regional trial court to the Court of Appeals. From then on, the trial court lost jurisdiction to issue said writ. When the petitioner asked the Court of Appeals for the issuance of the writ at that time, it thereby invoked the original discretionary jurisdiction of the latter to grant execution pending appeal. The third issue, in 1998, the Court of Appeal ordered the stay of execution pending appeal on the ground that respondent's liability still has to be determined. Petitioner argues that uncertainty of the outcome of the appeal cannot be deemed a just and proper ground to stay immediate execution of the judgment appealed from. Petitioner's allegedly precarious financial condition is not by itself a jurisprudentially compelling circumstance warranting immediate execution. Alleged financial distress of a corporation does not outweigh the long-standing general policy of enforcing only final and executory judgment. The court finds no need to determine whether filing of a supersedeas bond is, by itself, sufficient reason to stay the execution of a judgment pending appeal. So this issue was not raised. The execution of judgment before its finality must be founded upon good reason. Good reason imports a superior circumstance that will outweigh injury or damage to the adverse party. The reason, petitioner failed to show paramount and compelling reasons of urgency justice. Petitioner cites as good reason merely the fact that it is a small-time building contractor that could ill afford the protracted delay in the reimbursement of the advances it made for the aforesaid increased cost of the construction of the respondent's buildings. Petitioner allegedly precarious financial condition, however, is not by itself jurisprudentially compelling circumstance warranting immediate execution. The financial distress of juridical entity is not comparable to a case involving a natural person such as very old and sickly one without any means of livelihood, and here seeking an order for support and monthly allowance for substances, or one who dies. The alleged financial distress of a corporation does not outweigh the long-standing general policy of enforcing only final and executory judgments. A juridical entity has, other than extraordinary execution, alternative remedies like loans, advances, internal cash generation, and the like to address. Now, the fourth issue. Petitioner claims that respondents' refiling of a similar motion before the courts of appeals constituted forum shopping. The trial court did not pass upon the merits of the motion for a stay of execution filed by the respondent. Petitioner's offer to file counter bond was premature, inasmuch as the petitioner had yet to file its own bond. So in sum, the appellate court is authorized by the rules to order or to stay execution pending appeal upon good reason. Diesel's alleged financial distress by itself is not compelling reason to order immediate execution. On the other hand, mere filing by Jollibee as supersedeas bond does not automatically entitle it to a stay of execution. So the disposition of the case assailed resolution are set aside. No good reasons to grant extraordinary execution in the context of the present case. So that's it. That's my presentation. I, Julian Sanchez. Thank you for watching.